Hello, everyone. This is former Pennsylvania State Constable Stephen Wiggs of the 16th Ward, Allentown, Pennsylvania. And I'm bringing to you guys a read on part of the case law out of New York, People versus Rodriguez. And I'm doing this because this talks directly to my case in New Jersey, because in this case law, it identifies that the federal law protected my partner while he was in New York, whether or not he was working. In my New Jersey case, I was not working. But the federal law is directly geared toward officers that are off duty, which I was. So let's dig right into it, and you'll hear through the judge's decision how this pertains to the constable's office. 18 U.S.C. subsection 926B, also known as H.R. 218, or the it's federal law, but it's called the Law Enforcement Officer Safety Act of 2004, states, notwithstanding any other provision of the law of any state or any political subdivision thereof, an individual who is a qualified law enforcement officer and who is carrying the identification required by subsection D may carry a concealed firearm that has been shipped or transported in interstate or foreign commerce, subject to subsection B. As used in this subsection or this section, the term qualified law enforcement officer means an employee of a governmental agency is authorized by law to engage in or supervise the prevention, detection, investigation, or possession of, or prosecution of, or the incarceration of any person for any violation of the law, and has statutory powers of arrest, is authorized by the agency to carry a firearm, is not the subject of any disciplinary action by the agency, meets standards, if any, established by the agency, which requires the employee to regularly qualify in the use of a firearm, is not under the influence of alcohol or another intoxicating or hallucinatory drug or substance, is not prohibited by federal law from receiving a firearm. The identification required by this subsection is the photographic identification issued by the governmental agency for which the individual is employed as a law enforcement officer. Check it. The court notes that there is absolutely no case law or articles written about this statute apart from the congressional record statements at the time of its enactment. Thus, this is truly a case of first impression, which means there is no other case before this one regarding this law. Looking at H.R. 218, in terms of the known facts in this case, the court believes that defendant qualifies under it. As defendant points out, the office of the constable is mandated in Pennsylvania, in the Pennsylvania State Constitution. Constables are elected, sworn law enforcement officers with mandatory training requirements and state powers to make an arrest. Despite their lack of government funding, they are independent employees of the state of Pennsylvania whose identification cards are issued by the county as a state identification. Additionally, they are paid for their services by the district courts. The court notes that the grand jury minutes reflect that defendant showed the arresting officers his badge and his official identification, identifying him as a Pennsylvania State Constable, and a fact that the officers themselves admit they verified. As already noted, the people basically concede that defendant is a constable. Oh boy. It says, additionally, 42 PA subsection 2942 states that while a constable is performing duties other than judicial duties, regardless of whether or not he is certified under this subchapter, he shall not. So that's irrelevant, because constables are elected and we are directly charged with the conservation of the peace. So whether or not we're serving the judicial system, we're still on official duty. Let's see here. The clear implication of this statute is that when a constable is performing judicial duties, he is an agent, employee, or representative of the court, district judge, district justice, or judge assigning the judicial duties to him. In this case, the people independently verified by speaking with the assigning judge that the warrant defendant claimed to be serving was assigned to defendant and was still active. Thus, he was clearly performing a judicial duty. Moreover, a constable is elected within an electoral district, i.e., a ward, borough, or the like. The elected constable, who, with the approval of the court, appoints a deputy constables. Let's see here. Constables and deputy constables do not have uniforms, and they are not provided with municipal vehicles, but rather use their own personal cars. They are not paid a salary by any municipal subdivision as police and sheriffs are, but are more like independent contractors whose pay is on a per job basis. They are not considered state employees in order to receive legal representation when sued in connection with their duties. No one supervises constables in the way a chief supervises police officers or a sheriff supervises deputies. That's because the constable is the chief. No municipality is responsible for their actions in the way a city borough or township is responsible for its sheriff's office. In fact, the Pennsylvania Supreme Court has found unconstitutional legislation which attempted to place constables under the supervisory authority of the courts, despite being termed an independent This is what is important, because in the New Jersey case, in my case, the judge said that because we are classified under the same law that this judge in this case is reading as independent contractors, they wanted to say that we weren't law enforcement, and therefore that's the reason why he found me guilty. So it says here, under the same law and how this judge ruled, despite being termed an independent contractor by the courts, it appears that with respect to the work done by the constable for a court, the constable is performing judicial duties and is in fact employed by the court, district justice, or judge with which engaged his services. Again, according to defendant's attorney, defendant was actively performing judicial duties at the time of his arrest, as he was on his way to serve warrants within New York State, which were in his possession at the time of his arrest. Thus, there appears merit to defendant's argument that he is a government employee with the meaning of the term as it is used in 18 U.S.C. subsection 926B. Moreover, pursuant to 13 P.S. subsection 31, check this out. It says, thus, the fact that the Pennsylvania courts have full power to remove Pennsylvania State Constables from their positions, and the fact that they are elected officials conflict with the people's theory that Pennsylvania State Constables are not government employees. Based on this analysis, the court finds that defendant is an employee of a government agency, as that phrase is used in 18 U.S.C. subsection 926B. The court has reviewed all the other requirements listed under this section and finds that Pennsylvania constables come under the protection of 18 U.S.C. subsection 926B. Accordingly, the motion to dismiss the instant indictment is granted. Moreover, looking at the legislative history behind this law, it seems that defendant, in his official capacity of constable and in performance of his statutorily authorized duties, was the type of individual the statute wanted preempted from prosecution. This is a key point right here. Congress drafted this legislation to help stop and deter crime throughout the country. That's what H.R. 218 is for. Assuming that Pennsylvania State Constables are government employees, then defendant's prosecution is preempted by 18 U.S.C. subsection 926B, also known as H.R. 218, or the Law Enforcement Officer Safety Act of 2004, appears to have merit. Accordingly, the motion for inspection and or dismissal of the grand jury minutes is granted to the extent that the court has examined the grand jury minutes in camera and found the evidence before the grand jury to be legally insufficient. The people did not inform the grand jury that the instant prosecution was preempted if they found that the constable was here in the furtherance of his official duties, or if he qualified as a law enforcement officer under H.R. 218. Accordingly, the motion to dismiss the indictment is granted. Defendant's property, which was seized from him at the time of his arrest, is to be returned forthwith unless this decision order or judgment is stayed by virtue of the people filing an appeal from it in the appellate division. First Department. This constitutes the decision, order, and judgment of this court. This was dated November 3rd, 2006. The judge in my case ignored this. He ignored it. He said that he respected the judge. And then he said he didn't have to honor it because this was decided at the state level, basically, in New York. This didn't go to federal court. But the craziest thing is, he made a ruling based on federal law. Federal law. This judge, in my case, said that we weren't law enforcement. That constables weren't law enforcement. So the New Jersey judge said that constables weren't law enforcement after reading this. After reading this law. After reading this case law out of New York. You guys in New Jersey, you law enforcement officers in New Jersey always like to say New York is worse than New Jersey when it comes down to guns. You want to say that to me because I was a constable. Everybody wanted to say that to me because I was a constable. But New York honored the constables as a law enforcement officer and found us not guilty. For carrying a firearm in New York through my partner, Manuel Rodriguez. So, you guys are some of the worst people to talk when it comes down to us in Pennsylvania. Okay? We're famous in New York because of this case. New Jersey got it wrong, people. The judicial system of New Jersey got it wrong. They knew I was the guy. They knew I was the law enforcement officer. They knew I was the constable. They knew I was the peace officer. And under Pennsylvania law, constables are peace officers and police officers. They're one and the same. I've given enough information that pertains to that. So, that concludes our meeting for today. New Jersey, you're crooked, you're dirty, and you're being exposed. The judicial system of Essex County, New Jersey is being exposed right now. Peace.